Yes, sir.
Yes.
Yeah.
Thank you. Just a moment, I'll take a laser pointer. So I'll be talking about all the sections of the Telecommunication Act 2023 and what are the major provisions in that. So in next 90 minutes, of course, if you want to go very deep, minor details of each and word and all, it will take slightly longer time. But broadly, we'll be able to cover all the aspects which is part of the Act. So the chapter 1 of the Act, let me start with chapter 1 of the Act, which is called preliminary. So in this particular chapter, the title of the Act is defined, that is Telecommunication Act 2023. In addition, it says that the Act is applicable to whole of India. That means it's applicable to the entire part of our country. In addition, uh, in case of offenses, in case of, there is a chapter on offense. So if offenses are even done outside India, so those are applied to outside India also in respect of only offenses part of it. For example, if somebody is trying to hack Indian telecommunication network, so that particular offense, whether it's done from outside India, that would also, the Act would also apply onto that. And there is a provision in this particular chapter that the provision of the Act will come into force once uh, it is appointed, a date is appointed for that. So generally, either you can make entire Act in force in one day, or there is a provision that clause by clause you can make the part of the Act in force. So in DOT, what we are trying to do is that we have made some of the provisions in force, and some of the provisions we are still framing the rules. And once those rules are framed, those provisions will come into force after that. In addition, there are definitions given in this particular section. For example, what is the definition of authorized entity or facility provider? So what I'll do, I'll try to explain those terminology while I go through the other sections where those are referred, so that you know the context and then able to understand in a better way. So now let me move to the second chapter, which is very, very important, which is about power of authorization and assignment. So this time the terminology which is being used is authorization in place of license and so many other terminology it was there, but this time it is authorization and assignment, two terminology. So let us discuss that. So if you read this particular chapter, chapter 2, so in that what is given is that central government will have power to authorize an individual or any company or any association or body of individual, three things. One is to provide telecom service. That means government can authorize a entity to provide a government service. Second is telecom service. Second is to establish, operate, maintain and expand a telecom network. And third is to possess a radio equipment. Here, the important point to understand is that now you can see that a particular entity can ask only for authorization for providing telecom service. In that case, he may lease, he may take network on lease from other providers. So now there are three distinct authorization. If you talk about the current operators like Jio or Airtel, so I mean, in the current regime, it will be assumed that they have all the three authorizations. But in future, perhaps if a company comes and they only want to provide telecom service and they do not want to have their own network, those are the possibilities which has come into the new act. So this is about authorization. In the act, you will have the terminology called person. So person defined in this act is basically either an individual or a company or association or body of individual. So I have given the full form instead of writing person here, but wherever the person word is referred in the act, it means all these. Okay, in this chapter itself, it also have a provision that those authorized entity, those companies or individuals or body of individuals, so we are allowing merger, demerger, acquisition, or other form of restructuring of these entities. So Act itself is allowing. So we had these provisions earlier also, but that were not part of the Act, but that were kind of executive orders through which we had allowed. So now it is part of the Act itself that merger, demerger, acquisition, and other restructuring of these entities are actually allowed. Now let's talk about the second terminology, which is called assignment. So one is the authorization for three purposes which discussed, and other is the assignment. Assignment definition is for allocation of the spectrum. So right, so there the assignment word comes. But before we move to that, there is one provision which says that I think DGT sir want to say something, but voice is not coming. So maybe somebody can WhatsApp me so that I understand what sir is trying to say. So what I was talking in this particular clause of this chapter, that whatever spectrum was assigned or whatever license or registration or permissions were granted under the previous Indian Telegraph Act or Indian Wireless Telegraph Act 1933, those will remain valid. Important point is that even if this particular act comes into force, provisions comes into force, all the earlier decision of assignment, giving license, registration, permissions, all will be valid. And what will be the validity period? If that validity period is already defined, for example, earlier we had assigned spectrum for say 20 years. So those validity will remain for 20 years from the previous date. And wherever
nobody wants is it HP and
I think we are having some noise coming. So please allow me to mute them.
zeros. That means one of our younger that AD.
So give me a moment. I mute those persons directly from here. Right, thank you. Let me move back to my PowerPoint. Okay, I hope the PowerPoint has become visible. And in case earlier assignment or licenses do not have any validity period, then in that case, the validity period will be 5 years from date of appointment, from the date that particular provisions comes into force. And those entities would have an option to migrate to the new regime coming under the new act. So three things. One is that original validity. Second is wherever there is no validity, 5 years, and they'll have an option to migrate to the new regime. Okay. This particular chapter also have a provision that for KYC purposes, we require verifiable biometric based identification. So earlier, this was not there. So when we frame the rule, perhaps we'll be making biometric based identification mandatory. So one is say Aadhaar based, and we can have a different method of biometric identification also. Those will be spelled out in the rule, concerned rule of this particular provision of the Act. So there is another provision about allotment of different identifiers. So the Act gives power to central government to allocate telecom identifiers. So for example, we issue numbering series or sort code. So in the Act, we have made a provision that the central government can allocate those identifiers. In addition, there are certain identifiers which are actually given by ITU or other international body. For example, in case of a mobile, you have a country code. So the country code is allocated by ITU. So central government can allow use of telecom identifier, which is allotted by international bodies such as ITU. And for example, there are many kind of ITU, you can see identifiers you can see in the left diagram. Some of it are issued by Department of Telecom and some of it may be coming from ITU. So these powers are also with central government.
अशोक जी एक छोटा क्वेरी था, if it is possible, it's okay.
Yeah, please.
When we say person, it is in place of customers this time.
No. Person definition is a company or a body corporate, any entity who is being authorized, right?
So, but in the act, normally it is referring to customers, not the service providers or the.
No. You just read the definition first.
Okay. So
just read the definition. Yeah. Thank you. So about assignment of spectrum. So here also the provision in the act is that central government shall assign a spectrum. So here the word now being used is assign. Earlier we used to say allocation of spectrum. Here the terminology used is assignment. So whenever there is a assignment word, it is assignment of spectrum. So this has said that generally government should assign spectrum through auction process. The main process for assigning spectrum is the auction process. In addition, the Act has provided a specific schedule called Schedule A. अच्छा मुझे थोड़ा secretary बुला रहे हैं. Can we just pause for 2 minutes, DG sir, if you allow me? I'll just go and come back. So I'll just be coming, sir. Please allow me, sir. Thank you.
तो DGTHQ ऑफिस से आवाज नहीं आ रही है. DGTHQ से साउंड नहीं आ रही है.
Because they are muted.
Okay, sir.
Sir, good morning. Sir, if you allow, there was some question relating to the definition of person. So with your kind permission, I think we may initiate the discussion on that subject till Ashok joins back.
Yes, sir. I started that point because as per section 3, subsection 7, it is saying that services to be given to the person. So I felt person here means customer, not the service provider.
So I think the request is to follow the definition of the person as provided in section 2, or let me just say in the section 2, and at J specific place. Whenever an act is applicable, the individual has to go with the terminologies well defined within the definitions given in the act itself.
Yes,
so
sir.
if you read it, it specify person shall include an individual, comma any company or association or body of individuals, whether incorporated or not by whatsoever name called or referred to.
Yes, sir.
Right. So the specific word may be applicable in the relevant cases. So I think better way is
So
to
somewhere
apply as per the need. If it is in respect of the say customer, then the definition would change.
Sir,
Okay, sir. Thank you.
sir,
Right.
shall I start, sir?
Yeah, I think we try to utilize your absence.
Thank you, sir. Thank you. Okay, so there is a schedule 1A which gives list of purposes for which assignment of spectrum can be through administrative way. For example, radio backhaul, the assignment is through administrative way. Satellite services, certain satellite services, BSNL, MTNL, or any government purposes, amateur radio, these all are listed in Schedule 1, where we can assign through administrative way. And government also has a power to actually modify that schedule. So tomorrow, if you want to add or delete something, we can do through that particular schedule. But only thing is that whenever there is a change, that has to be put on the parliament, right? We have to place on the parliament for information. This particular chapter also talks about that central government will make national frequency allocation plan from time to time and notify that through notification that would be uh, made public. In addition, we have also provision for refarming of spectrum. So whenever we say refarming means repurposing, the definition is also given in the Act. Repurposing means suppose today it is being used for space related activity and tomorrow we want to use that spectrum for say mobile. So that's the refarming. Even suppose today it's being used for say 2G technology and tomorrow I want to use same spectrum for 4G or 5G. So that these are the aspects of refarming. So those are allowed under the Act. And there is a terminology called harmonization of spectrum. So that means harmonization is nothing but rearrangement, right? So for example, an operator has got spectrum in say 900 megahertz band, but from different segment. So tomorrow you can club and you can give a contiguous kind of spectrum, same amount of spectrum in a contiguous way so that it can be utilized better. So that is aspect of harmonizations. So these two activities, in fact, was being done earlier also, but it was not backed by the law, right? So now it is backed by the law itself. The other provision is that spectrum, whatever we allocate through auction, that will be technology neutral. So our act enables technology neutral use of spectrum. So this was also provision earlier. I mean, after we have started auctioning spectrum, we have made it technology neutral. There is a new concept to promote optimal utilizations of spectrum by secondary assignment of spectrum. This is very important. We are not doing as of now. So suppose a spectrum is allocated for a purpose to an entity. There is a provision that we can assign same spectrum on a secondary basis. So although the primary it is allocated for one to one entity for one service, but the Act allows is to give it to any secondary assignment. This would be possible once we have technologies in place for sharing of spectrum and all. But this is the enabling provision which we have in our Act. The government now also have a power to terminate earlier assigned spectrum or part of it in case the same is not being utilized. And it also has a provision to establish monitoring and enforcement mechanism for spectrum. So basically, this is the WPC work which they are doing. So their work is now part of Act itself, right? There are other provisions. I think it's a repeat one. Let me go next. The Act also provides for permitting those entity for sharing, trading, leasing, and surrender of assigned spectrum. So now, earlier also some sort of trading and sharing was allowed. This time it has come onto the Act, although the rule will spell out in what case those would be allowed and what will be the SOP. Those will be defined in the rule, but Act has provision for this also. Now let's move to the next chapter, which is very, very important. That is called right of way for telecommunication network. In fact, the rules are also issued for this particular chapter, but our focus today will be on the Act. Some other day we can have a look at the Act rule itself. Okay, so there are two important definitions before I move to the provisions in this particular chapter. These definitions are given in the chapter itself. So one definition is the facility provider. So facility provider here defined is the central government or authorized entity. That means the government itself or the authorized entity. That means our telecom service providers or the network providers. And it also says that it will include all the contractor, subcontractor, or agent. If suppose Reliance Jio or Airtel, or for that matter, we give this work to any contractor, subcontractor. So those are also defined as part of facility provider. And then there are property which are categorized like public property and private property. So it's a clear definition which is given. So all the central government properties, state government properties, local authority property, any institution, any non-government entity managing public facility and notified by central government, these all would be categorized as public property. And those who are not part of this definition will be called private property. So a whole lot of properties are now categorized as public property for the purpose of ROW. And then we have a private property. Now let's come to the provisions of the Act itself. So one of the provision of this section says that we have to provide ROW in a very, very fast manner and within the timeline. So these timelines would be spelled out in the rule that how much time a permission is to be given for ROW in respect of public property. And then in case that particular public property owner want to reject the request of those entities or facility providers, that should be on valid ground, and also they have to record in writing in their files. So it's very strict provisions are being is there in the Act. And then in respect of damages, for example, if facility provider damages the property to some extent, maybe if he has to cross the road, so of course some damage would happen. So either it has to be restored by the facility provider or compensation to be provided as agreed mutually. So these are three types of provisions. In case of private property, for private property also there is separate clauses. So in this case, it says that the private property owner will provide ROW on agreed terms. That means of a telecom service provider or facility provider and the private property owner would enter into an agreement for that ROW. In case there is disagreement that the private property owner do not want to give ROW, whereas the facility provider says that it is required, ROW is required in that area. In that case, central government will take a decision. So there are detailed provision I'll talk about. And very important, the last point here is very important, that whenever a ROW is given, it should be non-discriminatory and non-exclusive. So here, example can be that in a ROW, I mean, a resident welfare association, RWA kind of environment, generally we see that they have given permission only to say Jio or Airtel, and they are not allowing BSNL or other telecom service providers. Now, Act has a provision that private property owner cannot discriminate or cannot give exclusive grant of right of way to one service provider. So that's very, very important clause, and that will really help other telecom service providers, particularly BSNL, who struggle for ROW. There is also a provision for establishing common duct and cable corridors, the provision says that central government can notify those infrastructure projects developed by public entity, government or public sector, etc. That will require that that particular infra project must have common duct or conduit or cable corridors for telecom network. So now perhaps with this act, we can notify certain project, maybe road or maybe some other project, that mandatorily they have to also provide duct or conduit or cable corridor. So this also will be part of rule and some notification will come. Maybe we need to work with other ministries who are engaged into it before we actually notify. There is a very important provision that, for example, if suppose a property owner particularly have given permission to a authorized entity or a telecom service provider, and then that property owner for some reason want to remove that telecom infrastructure or reallocate or do some alteration in the telecom network. In that case, the act provides for that, that property owner may ask for it to the facility provider, right? So earlier I have given ROW permission. My property was there, but I have given ROW permission. But because of some reason, maybe I want to construct my house or maybe I want to do something. So I have a right to request or ask the facility provider or telecom service provider for removal or relocation or alteration. Uh, if I was paid compensation during the ROW, right? So I have to pay to the facility provider for those removal or relocation which I am requesting. So that means the private property owner, if he had got compensation earlier and prematurely he is withdrawing ROW or asking for removal or relocation, he has to pay back mutually agreed amount. And in case here also there is a possibility of dispute. In case there is a dispute related to dislocation, etc., or the amount related to this, how much compensation has property owner has to pay. In that case, district judge decides the matter. So in our entire act, if you see many places, wherever there is a financial related dispute, it is being referred to district judge, and wherever it is decision related disputes, it is being referred to district magistrate. So in this case also, if facility provider is not complying, that means property owner has given a request or asked for relocation, but he's not listening. In that case, he can go to DM and DM will decide the matter. So district judge and DM for two purposes, it's given in the provision. Now there can be many other dispute related to ROW. So there is a provision, clear provision in the act that either district magistrate or there is another power given to central government that they can notify any other authority, right? And that authority should be located in the jurisdiction of that property where ROW dispute is happening. So DM is the right kind of a entity. If some places in place of DM, suppose some municipal corporation is the in charge, so there you can authorize some of the authority as dispute resolution authority. So the DM would take final decision except where compensation related dispute is there. Wherever there is a financial dispute, DM will not decide. In that case, one has to go to the district judge. So the dispute arising related to compensation, that will be taken care by the district judge in the same area where dispute has happened, right? And there is a very uh, bold line which I have given, that in the act it is written that every determination of a dispute either by district magistrate or district judge under this section shall be final. That means it appears that there is no way one can escalate further. But once we read the rule, we'll come to know that what exactly how this has been dealt in the rule. Okay, now let's move to the next chapter, which talks about standards, public safety, national security, and protection of telecommunications network. So here also power has been given to central government to notify standard and conformity assessment measures. So for what central government can notify? The first about the telecom equipment itself. Second, standard or conformity assessment for identifiers, telecom network itself, and then also the telecom services. But in case of telecom services, since certain powers are with TRAI, so DOT has to consult TRAI before we make any standard related to telecom services. For example, here is that for UCC, unsolicited commercial call, we all are aware that there is a regulation by TRAI. But in this act, we are also we need to also provide a rule related to that, and there are certain other provision related to telecom service. So DOT has in fact referred those clauses to TRAI for their recommendation, and some of the recommendation has come and some of the recommendation are pending at TRAI. Then DOT will make rule related to telecom services for standard and this conformity assessment measures. For manufacturing, for import, for distributions, these are the also words given in the act where government can notify any standard. Even government can notify standard for sale of telecom equipment, telecom security, either for service, telecom service, or a telecom network, both. For both, we can notify rules or standards separately. Cyber security for telecom service and network, encryption and data processing in telecom. So the Act has given so much of power to notify different standards. So basically, whatever TEC and CCS, etc., are doing the work, these provisions would be like executed by those agencies of DOT. Now there is a provision related to public emergency or public safety, right? So basically what this particular provision says, one of the uh, clause says that for in the interest of sovereignty and integrity of India, defense, security of state, friendly relation with foreign state, public order, or preventing incitement to the commission of any offense. If these are the case, then government can take temporary possession of telecom service and network. So there is a provision that in case of national interest and all these other provisos, DOT or government can take possession of telecom network or telecom service. And also, particularly for disaster, we can enforce priority routing of call. That means we can decide and communicate to those authorized entity that these are the numbers where they have to provide priority routing of call in case of a public emergency or public safety. There is some more provision in this particular clause. Here also it talks about that in the interest of sovereignty and integrity of India, friendly same provisions, or for preventing incitement to the commission of any offense. So what this provision says that government can say that a particular message or particular class of message. So here also, if you look about, if you take the definition of message and class of message, so voice call, data call, video call, message, everything is covered in the definition of message. Although here we are referring as message or class of message. So it's not only message, but it is also voice call, video call, everything. All kind of communications are covered in the definition of message. So government can actually ask not to transmit a particular message or class of message. Government can issue an order for interception of those messages or class of message, or we can detain that. If suppose message is transmitted in the system, we can detain it, or we can disclose that to a particular officer, or we can suspend that in transmission of that message. The one proviso which was earlier also there, that press messages will not be detained or intercepted. So these are other than press messages. So basically this will allow whatever we do for alias, interception and all. So that is related to that. So definition I have noted down below, that message means any sign, signal, writing, text, image, sound, video, data, stream, even intelligence information sent through telecommunications. And whatever we will do for a prescribed duration. So it's not, nothing is unlimited or for undefined time. So order has to be there for a prescribed duration. All those actions can be taken for a particular duration. So there is another provision in this chapter about measures for national security. So here also it says that in the interest of national security, friendly relation with foreign state, in the event of war, government may issue certain direction. So that direction may relate to telecom service, equipment, network, identifier, standard of manufacturing, import, or distribution, or procurement of telecom equipment from trusted source, or government can suspend, remove, or prohibit use of a particular telecom equipment. So we can ask that in this situation that a particular make and model devices not to be used in telecom network has to be switched off, right? So we can suspend, remove, or prohibit uh, uh, from a particular country or from a particular person. So country means we can say that any equipment which is running in the telecom network, if it is from X country, you can remove or prohibit. Here person means company or entity. We can remove a certain entity or company for that purpose. Uh, it also has a provision that government can take over control and management uh, of the telecom network or telecom service itself. It can suspend operation uh, or entrust any other authority to manage. For example, you can take over, you can ask BSNL to take over a particular uh, uh, network, or say tomorrow you decide that a private network, I should not say take name, but government may decide that BSNL to take over in this particular scenario, or government itself can take over and manage that. So these are provisions. There is also provision related to cyber security. So that talks about protection of telecom network and telecom service. So wherever these provisions are there, there is a distinct, they are saying about telecom network and telecom service, because now these are separate authorization. So this authorized government to issue measures to protect and ensure cyber security. So which include collection, analysis, and dissemination of traffic data. So basically, what does it mean? That uh, government can request certain data from the telecom service provider for uh, cyber security related measures. For example, today we are collecting a whole lot of data for our DIU related work, right? So basically, this particular provision covers that we'll be able to seek data from telecom service provider. For example, if you want CDR data for analyzing any cyber security related fraud, or cache data you want, so those are kind of will be covered here. Then government has power to notify or declare a telecommunication network or part of it as CTI, critical telecommunication infrastructure. So through notification, So this particular provision don't require any rule. We just need to notify that a particular telecom network or part of it is a CTI. And once it is CTI, there are certain provisions related to CTI which every entity has to take care of. For example, government can define different standard or security practices or upgradation requirement and the procedures for those CTI. So this will come in rule. So for notifying a particular telecom network as CTI, we don't require any rule. This has come into force. So maybe DOT will constitute a committee and identify which particular telecom network or part of it we should notify as CTI. But what standard it should follow, what security practices it should follow, this will be notified through a rule which DOT would be working. And then government can also give direction to authorized entity to transmit specific messages. For example, we send a lot of uh, education and awareness message about cyber security. We send so cyber security related messaging to particular uh, users in a particular region, area, or in the entire country, we can ask those TSPs to send those messages. So that power is also coming from provision in this particular act. In fact, we are doing it today. We are doing it through the license conditions. Now it will become part of the act and rule itself. So now let's move to chapter 5, which is Digital Bharat Nidhi. So basically the USOF is now come.
Somebody,
Yes.
sorry to interrupt. Whether we can take the question just now or in the last?
I think, sir, if it is one question, please go ahead, sir.
Related with the cyber security, whether these telecom rules will be applicable to cellular network only, or it will be to non-cellular networks also. Like there are so many entities building the networks for the for creating smart infrastructure in various verticals, say like smart metering, electricity metering, and those devices may be vulnerable, and ultimately these devices are connected to the cellular network. These were discussed at length for the security point of view during the time of previous secretary. So whether these telecom rules will cover that one also, or it will be only for the TSP networks?
So my understanding, sir, so although these rules are under preparation and it's going off a lot of changes as of now, so I cannot say with a concrete, but my understanding is that our act uh, normally will apply to authorized entity, normally will apply to authorized entity. But our act also says that the offenses the first of all act will apply to the entire India, and offenses will apply to entire India plus outside India. So in case it is offense, suppose there is an offense which affecting the telecom service or telecom network, in that case our security provisions or rules should apply. That's my understanding, sir. But actual rule once
I would like to add something if
can we sir do it in the end so that I'm
yeah,
able
sure,
to finish.
sure. Yeah.
Thank you, sir.
Why
Let
not?
us park this question and maybe we can
Yeah.
discuss at the end, sir.
Okay.
Thank you, sir. Now let's talk about the next chapter, which is chapter 5, which is Digital Bharat Nidhi. Basically, the USOF now is termed as DBN or Digital Bharat Nidhi. So as I said that USOF is now Digital Bharat Nidhi or DBN. So the provision in this particular chapter says that uh, the amount in DBN will not lapse after a financial year. So whatever amount we are collecting from authorized entity and a portioning for USOF or now Digital Bharat Nidhi, uh, it will not lapse. That means although it goes to Consolidated Fund of India, but it will not lapse even after a particular financial year, right? So, and the process they have defined is that whatever amount will be collected, generally out of the 8% license fee, today 5% goes to USOF or Digital Bharat Nidhi, right? So whenever we are collecting, it has to go to CFI first. And then from the CFI, central government normally allocates to us, to DOT, the money for the activities which are uh, we have to do part of this particular provision in the Act. So basically this time, earlier USOF, as the name was suggesting, it was for only universal service provisioning. So now the scope of this has been expanded in the Act. So in addition to the service provisioning, now we can utilize this fund for promoting R&D. Maybe we can fund R&D projects. In fact, we have started doing that. We can also fund pilot project, consultancy, assistance and advisory support for universal service. For example, if you are doing, say, BharatNet and you require to do certain pilot project or certain consultancy requirement or advisory requirement, those are also covered in this particular universal service provisioning. And in case you want to introduce certain telecom service or certain technology or product, for that also we'll be able to now fund from the Digital Bharat Nidhi. So the four items are from one item, now there are four items which can be funded through DBN under this Act. For this also the rule will come, I mean, will be prepared and floated and then will come in force later on. So now let's move to the next chapter, which is chapter 6. It talks about innovation and technology development. So in this act, in this particular chapter, we are talking about regulatory sandbox. And this has also defined what is regulatory sandbox. In the chapter itself, there is a definition of regulatory sandbox, which is written here, that a regulatory sandbox refers to a live testing environment where new product, services, processes, business models can be deployed on a limited set of users and for a specified period of time, and we will give certain relaxation which is required. For example, if somebody want to test a particular service in a live environment, so we can allow that, and even if they're not following certain provision of the act or rule, that can be relaxed for a particular duration of time. So this is an enabling definition of regulatory sandbox. So, and it says that central government may, for the purpose of encouraging and facilitating innovation and technological development in telecom, create one or more regulatory sandbox. For example, I can declare NCA Ghaziabad campus as regulatory sandbox for testing X, Y, or Z, right, in a live environment. Or we can define, say, a particular district or particular, say, a block or mandala as a regulatory sandbox where new kind of services which has been developed by somebody, they can deploy in a live environment and test and mature that equipment. So these are the enabling provision in the Act for regulatory sandbox. Now, a very important chapter which has been added is protection of users. So this provision is talking about measures for protection of users. So this is very important that this chapter says that if you want to send certain specified message, so there is also a definition of specified message, particularly those commercial communication is now being called as a specified message in the Act. These are defined. So in case I want to send a commercial communication to anybody, I have to take prior consent of the user. So this is very important. Why? Because today, although we have concept of do not disturb registry, and it is some sort of See, it takes that the consent is already given, and then once I register into do not disturb register, then only I will not get messages. So it's a reverse one. Whereas uh, as far as my reading of this provision goes now, uh, it's a no consent kind of, and I mean unless I say yes, you'll not be able to send me a commercial communication. But let's see how we do it in the rule. So we have to see how rule evolve. But my first reading, I mean, I understand that prior consent would be required for commercial communications. There is also a provision that government has to provide a mechanism for users to report. So if I want to report that somebody is doing commercial communication without my prior consent, I should have some mechanism to report. And if that mechanism are in place, suppose government has established that, then and also it has provision that online mechanism for users by authorized entity to register any grievance. So suppose as a user, I want to register any grievance. So every TSP has to provide me an online mechanism for that handling of that grievance. So two different aspect. One is mechanism for user to report. This mechanism perhaps government need to make, we need to make in DOT, and operators also for grievances, they have to have some online mechanism. In addition to those provisions, now certain duties of the users are also defined in the Act. And that says that the users, those subscribers, should not furnish any false particulars, suppress any material information, impersonate another person, while establishing his identity for availing the telecom service. So related to KYC, while KYC is done for providing a service, there is a duty of user that he should give correct information. And users also have a duty that if some information they have to share under this Act, they should not fail to share that information. So no user shall fail to share information as required under this Act. So in the Act, in the rule, if we make that in certain scenario, the users are required to share certain information, they should not fail to, otherwise this will be treated as violation of the rule or offense of the rule. So the provision about dispute resolution mechanism. So there are certain provision given in the Act itself. It says that government has to establish online dispute resolution mechanism. So this comes on our head, DOT, and there will be a role of LSA, it seems, for dispute resolution mechanism. And in this dispute resolution mechanism, all the service provider, here we call it authorized entity, has to participate in dispute resolution mechanism. That means in this particular online mechanism, all the authorized entity would be onboarded. If it is a portal based system, then they will be onboarded onto the system, or will provide them connectivity or API to connect to this system. So this is something which will actually come. It has also a safeguard provision in this Act, in this chapter, that this will not affect rights of consumer under the Consumer Protection Act. That means the provision in this particular chapter will not override any other provision which is available in Consumer Protection Act. Now let's move to the next chapter, which is it's very important, and perhaps LSA may get certain role related to this, but rules are under approval as of today. And actually, I have not gone through, but I feel that there will be a role of our LSA. So it is about adjudication of certain contraventions. So if there is non-compliance of certain provisions of this act by authorized entity, this comes into the picture. So, so how it will function? So there is a concept of adjudicating officer. So what the act says that such officer will not be uh, below the rank of joint secretary, right? So that means in our case, a DDG level officer. So if adjudicating officer has to be appointed by the government, it will be DDG level officer in case they decide to appoint at LSA level. And then there is a concept of appeal committee, designated appeal committee or DSC. So here it is defined as it will be having members, and those members will not be the below rank of additional secretary. So it's a additional secretary level committee. So this is to be constituted by the government. And then it says that the entire functioning of this functioning of these two committee and officer would be digital by design, right? It has to be digital by design. That means online system we have to build. In fact, the work on this particular aspect is already going on. And then uh, these two educating officer and this committee will have power equal to civil court. Just see the power equal to civil court, and all the proceeding will be treated as judicial proceeding. So very huge power has been given for this functioning in under the act. So how this will operate? Suppose there is a breach of terms and condition of these authorized entity. In that case, the work will start from I'll call AO now, educating officer. So AO has to do an inquiry. Suppose AO is convinced that a particular authorized entity has breached a particular terms and condition of the authorization, then AO can start the inquiry, and then and it will give a hearing to those authorized entity, and then it can pass and direction, right? That you do this or do that or don't do this. Any kind of direction can be passed so that such breach which that particular AE was doing is prevented. So first is that you are giving direction to take curative action on the breach. In the next stage, if that is not happening, there is a provision that the AO can impose civil penalties. Civil penalties means in terms of amount money, which I'll talk about how much for what condition. And once that penalties are imposed, this AO can also recommend suspension, revocation, or curtailment of the duration of the authorization or assignment. So very huge power is given to the AO, right? And that we have to send to central government. That means to DOT HQ, and DOT HQ will take action on the recommendation of the AO. And central government either accept the recommendation or do not accept. And suppose it has accepted, later on the government may ask to comply to the authorized entity or do some remedy. Once those are done, it has power even to reverse that suspension or recommendation. So all powers vest with the central government. That means in our case, it will be DOT headquarters. So these are kind of a step of in case of a breach of terms and condition of the act. There is very interesting provision related to voluntary undertaking for contravention. So what it says that suppose the authorized entity is aware, has become aware that they have done certain breach of the terms condition, or they are doing certain breach of the terms and condition, even before an inquiry has started. So if they are aware of, so they can submit a voluntary undertaking to the AO disclosing such contravention and also what measures they have taken or they will be taking to mitigate such contravention. So that means if I have done something wrong intentionally or unintentionally, but I want to take remedial measure as AE, authorized entity, I can give an undertaking to AO, and then AO can actually examine that voluntary undertaking and accept or not accept. So once say, for example, let us assume that AO has accepted. In that case, there will be no proceeding. As I was discussing in the previous slide, there will not be proceeding because the AE itself has voluntarily come to you, have taken corrective measures, and you have accepted AE undertaking. So there will not be any proceeding further. So now, what will be the process? The first step, which I was talking about in the first slide. So basically, on a reasonable ground, suppose it has come to the notice of AO that some breach has happened, right? And the ground for that is reasonable. So AO has to give notice to authorized entity or authorized assignee of spectrum. And then there will be a process of hearing, right? So you'll give opportunity and you'll hear those authorized entity, right? And then during this process also, AE can be asked or AE itself can give a voluntary undertaking that I will take this action, that action to mitigate the violation which it has done. And there itself, AO either can consider or can accept the voluntary undertaking. If it feels that the AE has taken corrective measures, so it can accept and then close the case. But in case AE or that assignee do not comply to the undertaking, suppose today I have given undertaking as AE that I'll take these corrective action, but tomorrow I don't do. So AO can recommend or impose penalty as prescribed after giving a hearing. Here also it has to give hearing, or AE can appeal to committee. So suppose some penalty has been imposed by AO. Now he has an option to go to the appeal committee, which was where members are at the level of AST. And once they're also not satisfied uh, decision of the appeal committee, they can go to the TD-SAT in case of that dispute, or they can go to the civil court. So there are two provisions. One is they can go to the civil court, and one they can go to the TD-SAT. There are specific cases where either they can go to the TD-SAT or they can go to the civil court. And if you read the act, it appears that in case AO has initiated the action suo moto, that means there was no written complaint by somebody, that the TD-SAT would be handling. But if a particular individual has complained about a particular authorized entity, the violation by authorized entity, in that case, it will go to the civil court. So TD-SAT and civil court both would be there. So there is a distinction between a complaint-based the process and a suo moto. AO initiates the process based on his knowledge or maybe our audit or our internal inspection, etc. Okay, so now again, very important chapter of offenses. What will constitute offenses and what will happen? Chapter 9. So let's talk about the general provisions. So basically, the general provision is, suppose some person, company, or anybody is providing unauthorized telecom service or have created unauthorized telecom network, establishment of network or provisioning of service. So unauthorized way mein. In that case, the Act provide for imprisonment up to 3 years. 3 years or a penalty up to 2 crore. Its word is up to, not the absolute one, up to. So we will be, while those things are happening, we need to decide, or both. So these are the provision in case of. So basically, all those unauthorized telecom network which we along with police are able to unearth. So in that case, now there is a imprisonment, clear case of jail and the financial penalty, or both. The second is unauthorized access or attempt to access to telecom network, or unauthorized data transfer, or unauthorized interception. So one is the provisioning of service. If somebody is able to enter into telecom system and access telecom network information or data, or even the employee of a TSP is transferring some data unauthorizedly or doing unauthorized interception. So in this case also, same provision, that 3 years jail or 2 crore, up to 2 crore of fine, or both. So these are general provisions. There are also provision related that if somebody does unauthorized position of jammer, if somebody, so jammer word is not there in the Act. It says that if you are trying to block a telecom service by using some equipment, so practically we use jammer, or maybe in future you can use something else. So that is termed as unauthorized. Then if you have unauthorized radio equipment, or you have SIM box, the word SIM box is not coming in the Act. It's saying that any equipment where multiple number of SIM module can be provisioned. So basically they are talking about SIM box, but the word given is a generic word in the Act. Or unauthorized use of telecom identifier, or we are tampering, somebody is tampering telecom identifier. In all these cases, so here also it is a 3 years jail, but the penalty, financial penalty is up to 50 lakh rupees, or both. So this is the second provision which you have, general provision. This is also very important. Now there is power to search, right? Some sort of ED like power you are having, right? You can, so authorized officer may search any building, vehicle, vessel, aircraft, or any place in which he has reason to believe that any unauthorized telecommunication network or telecommunication equipment or radio equipment is kept, concealed, or take position thereof. So you can search and also seize. Search and seize power has come through this particular Act. So very huge thing. So let's see that who gets this power, how this power, which officers are authorized. So particularly it's sort of ED like power which you have got under this particular Act. Now, there is also provision related to supply of certain information to authorized officer, right? Suppose there is a apprehended civil or criminal case in a court, right? And we as a government require certain information, maybe about customer, maybe about call data, etc. So a authorized officer for that purpose can request that authorization is from central government, shall direct these entities, authorized entity or assignee, to furnish information, document, record related to telecom service to that particular officer. So now an officer can ask for certain information from TSPs if there is a requirement or apprehension that may be required for a civil proceeding or criminal proceeding in a court. So that's also a enabling provision. Now there are few more small chapters. So chapter 10 is a miscellaneous chapter. So basically it says about government has power to creation of security interest. So if you look at uh, the meaning of security interest, basically suppose MTNL or BSNL is taking loan from the bank and they need government guarantee, right? So that is called security interest, right? So this provision has come that even for any other service provider, in some aspect, if there is a requirement of government guarantee in terms of financial things, so that creation of security interest provision exists now in the act. Government can do that through this act itself. Now we also have a power that we can start a certification scheme for the person. Definition of person here also same. For operation of radio equipment on vessel or aircraft, right? So in a vessel and aircraft, you have radio equipment. So only certified operators are supposed to operate that. That certification can be done by we government or DOT in that sense. For amateur station operator also, we can have certification scheme now. The power has come to us. The act also apply for offences or contravention committed outside India. So this provision is coming twice. In the first also it was there, and in this chapter also there. But it says that those committed offences should relate to the telecom service or telecom network in India, right? So although you are committing those offences outside India, but it is affecting our network, our service, then this act can apply there also. The power to make rule. So from here, it's a clause 56 here, which gives power to the central government to make rule under various provisions. Those clauses are also defined in section 56, in clause 56. Then we have a power to amend those schedules, first schedule, second schedule, and third schedule. I'll talk about these schedules. What are these? But once you have amended, it has to be laid in the parliament. And there is a general clause on removal of difficulty. Suppose you issue a rule or you issue a regulation, but during implementation, you are facing certain problems. So you have power to uh, uh, issue certain guidelines or amend certain rules so that those difficulties are removed. That's a provision every act has. Now the next chapter is about repeal and savings. So for example, in this act, we have repealed our earlier Telegraph Act and Indian Wireless Telegraphy Act. These two acts are actually repealed. But along with that, it says that all the existing rule or whatever action has been taken prior to the new act coming into force will continue till those specific rules are actually replaced. So existing rule will not go away. It will be there. And there are certain validation of certain acts and indemnity. So basically, in our earlier act, there is certain provisions related to Electricity Act. So what this act says that those particular provision of Indian Telegraph Act will be valid even after we have repealed that till the Electricity Act itself is modified by the parliament. So there are certain saving clauses and in this particular chapter, last chapter. So now I'll talk about the schedule. So first schedule is a list of those items or the cases where a spectrum will be assigned through administrative process. And there are 19 line item. If you read that particular page, there are 19 cases. Basically, all central government, state government, defense, railway, certain satellite services, BSNL, MTNL, uh, radio backhaul, these would be part of these 19 cases where spectrums will be assigned through administrative way, not through the auction. And government has power to modify this particular schedule. Now, the second schedule is related to civil penalties, right? So basically, if you recall, that the penalty amount was mentioned that how much penalty can go. So In case of, AO has to categorize those civil penalties, that those contraventions, that whether it is non-severe, severe, moderate, major, or severe, depending upon certain factors. Those factors are actually written in the Act, that based on these factors, AO has to categorize it as severe, major. And if suppose it is categorized as severe, then civil penalty will be 5 crore or 1 crore, 10 lakh, 1 lakh, or written warning. So this is second schedule. Now, third schedule is related to certain provisions which is not covered in the schedule 2, and those are written here. For example, possessing radio equipment without an authorization or exemption except for the, so all those offenses covered under this are dealt previously, but rest will be dealt here. So here, basically only 50,000 is the civil penalty. Basically, this is talking about, suppose as individual, you have deployed a repeater at your house, right? So that signal booster kind of as an individual. So that perhaps will come under this, and penalties are also less 50,000. And the subsequent offense 2 lakh rupees, right? So 2 lakh, 10 lakh. So all these items are defined in third schedule. So these are the only 3 schedule which is there, and all these schedules can be modified by the central government at any point of time. Only requirement is that it has to be laid in the parliament once these are notified. So with this, I have concluded the presentation. In